Hi guys, and welcome to another episode of Attorney Javier's Law Lectures for Students. Today, we'll be having an overview, or as may be applicable, a review of the topic of partnerships under the Civil Code of the Philippines. Being an overview, today's discussion will be more general in nature. And if you would like more details, you can watch my full series on partnerships. Just look for it in the playlist section. Or, better yet, study the law, textbooks, and cases. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. This episode is also brought to you by Digest.ph, an online law library with over 70,000 case digests and full texts of Supreme Court decisions, all downloadable in Word and PDF formats. Use my promo code Javier Digest to get 20% off Digest subscription plans. Now, let's begin. And we start with the definition to provide context for this topic. So what's a partnership? Under Article 1767, a partnership is a contract whereby two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So, a partnership is a contract, but it is a special contract because it has its own special rules. Nevertheless, in case of silence or absence of a special rule on a particular matter, we can apply the general principles of obligations and contracts because a partnership is still a contract. Therefore, for a partnership to exist, the essential elements of consent, object, and cause must be present. Specifically for partnerships, consent requires at least two things: that the parties must have legal capacity and that the partners must consent to be associated with the other partners under the principle of delectus personae, which simply means that each partner has the right to choose who he will be partners with, because a partnership relation is fiduciary in character, meaning it is imbued with utmost trust and confidence. So a person is allowed to choose his partners because they will act as agents of each other and of the partnership, who can therefore be held liable for the acts of their fellow partners. As for the object, the partners may choose any purpose for which they will contribute money, property, or industry to a common fund. It may be to transact business, in which case it is a commercial or trading partnership, or it may be to practice a profession, as in a general professional partnership. In any case, the object must be lawful, otherwise the partnership will be void. As for the cause, the partnership must be established for the common benefit or interest of the partners, which, as per the definition, is the division of profits among themselves. That's the reason why they enter into the partnership, to divide the profits among themselves. So the definition, together with the essential elements of contracts, gives us the two tests to determine whether a partnership exists. First, is there an agreement or consent to make a mutual contribution of money, property, or industry to a common fund, the object? And the second test is there an intention to obtain profits and divide those profits among themselves, the cause? Okay? So once consent, object, and cause concur, the contract is perfected, and a partnership with a separate juridical personality from the partners will now be created. Unless, of course, the partners agree that the partnership is subject to a period or condition, in which case the contract is merely executory and the partnership will only begin to exist once the date arrives or the condition happens. Otherwise, if there is no period or condition, then the partnership begins at once. Only the essential elements are needed, and no particular form is required to create a partnership. So it can be created orally or in writing. Thus, a partnership is perfected by mere consent, making it consensual in nature. As a consensual contract, delivery is not required to perfect this contract. Therefore, the contract of partnership exists even though the promised contributions have not yet been given. Nevertheless, the partners still have to give their contributions because a contribution of money, property, or industry to a common fund is the second requirement needed for a partnership to exist. But how much should a partner contribute? It depends. If a person joins the partnership as an industrial partner, he does not have to contribute money or property because his contribution is labor or industry. For capitalist partners, they may agree on what property or how much money to contribute, but if there is no agreement, they should contribute equal shares to the capital. The capitalist partners may agree to go all in by contributing all the properties that they currently own to a common fund so they can divide the properties and its profits among themselves. This is what is known as a universal partnership of all present property, under which only current property can be contributed and not future property such as those acquired by inheritance, legacy, or donation. Now, instead of going all in, the partners may choose to retain their ownership of their properties and instead contribute only a usufruct, granting only a right of use to the partnership and putting everything they earn or acquire in the common fund. And this common fund will now belong to the partnership. This will be known as a universal partnership of profits. And in case of doubt, if you're unsure if it is a universal partnership of all present property or of profits, the partnership will be presumed to be one of profits because it is less onerous as it imposes less obligations by preserving the partners' separate ownership of their respective properties. The partners may also choose to form a particular partnership instead, where the object can be the use of determinate things or their fruits, or to complete a specific undertaking, or the exercise of a profession. In any case, if the value of the money or property contributed is 3,000 pesos or more, then the contract of partnership must appear in a public instrument, meaning that the contract has to be notarized and then submitted to the Securities and Exchange Commission or the SEC for registration. Now, if the contract is not notarized or registered, that will not affect the existence of the partnership because a partnership is consensual in nature and created by mere consent. Registration is not needed to create the partnership, but is only for the purpose of setting a condition for the issuance of licenses to engage in business or trade and to give notice to third parties. So even without notarization or registration, the partnership will still exist and can be held liable for contractual obligations. Now, if immovable property like land is contributed, the partners must attach an inventory to the notarized partnership contract. Without this inventory of real property, the partnership will be void. Now, every partner is a debtor of the partnership for whatever he may have promised to contribute. Being a debtor, each partner has the following obligations. Before delivery, he has the duty to preserve the thing with the diligence of a good father of a family. And if the determinate thing is lost before delivery, the partnership will be automatically dissolved because it cannot exist without the promised contribution. But if the thing lost is generic, then no problem because the debtor partner can deliver another thing of the same kind and quality. However, if title over the determinate thing was transferred to the partnership before delivery, the partnership now exists and the partnership bears the loss as owner, following the principle of res perit domino. Next, the partner must also deliver the thing promised, of course, together with its fruits on the date agreed upon without need of demand. And in case of delay, he will be liable for interest and damages. After delivery, he cannot be held liable for breach of warranty against eviction if the partnership is judicially evicted from the thing. And once a partner has made his contribution, he has no more duty to make any additional contribution. However, if subsequently the partnership faces an imminent loss and there is no stipulation prohibiting it, then and the capitalist partners, they may agree to give additional contributions to save the partnership. But since a partnership is a voluntary relation, no one can be forced to give additional contributions against his will. So in case a partner refuses to give additional contributions, he will instead be required to sell his interest in the partnership to the others who want to save it. Of course, this rule does not apply to the industrial partner who only contributes their industry. Now, what do the partners get in turn for their contributions? Of course, the reason for entering into the partnership and giving contributions or the cost of the contract is the division of profits. And in creating the partnership, the partners may agree on how profits and losses will be distributed. They can write their shares in the partnership agreement. They may even agree to let a third person determine their respective shares, but they cannot assign the determination of shares to one or some of the partners because of the possibility of abuse. That partner may choose to receive all the profits and none of the losses. He might give the losses to someone else. Okay? That is why, in crafting the rules on distribution of profits and losses, the partners cannot insert what is known as a pactum leonina, which excludes one or more partners from any share in the profits or losses, making them bear the lion's share of the risk. In case there is such a stipulation, only the stipulation will be void, but the partnership will still be valid. So, to determine the profit of each partner, you check what is written in the agreement, okay, on how to distribute the profits. And if there is none, first you pay the industrial partner his share in an amount commensurate with the work he performed, and then the capitalist partners can now divide what is the remainder. Okay, they can divide it amongst themselves in proportion to the shares they have contributed. So if their contributions are equal, then their profits are also equal. Now, the partners may also agree on how the losses will be distributed, except that they cannot include the industrial partner who cannot be held liable for losses because he cannot take back the work he already performed. Since his work is his contribution, if the partnership fails, then his work was in vain. His share in the losses is the fact that he will not get paid for the work he performed. So, to determine how to distribute losses, again, you first exclude the industrial partner. Then, you follow what is written in the partnership agreement. If there is nothing written on how to distribute losses, then the losses will be distributed in the same proportion that profits are distributed. But, if there is no agreement on how to distribute profits, so there's nothing to follow, then losses will be distributed according to how much each partner has contributed. So again, if they made equal contributions, then they will share in the losses equally. Except that again, the industrial partner will not share in the losses. One more thing that the partners have to agree on in creating the partnership is the partnership name, which may or may not include the name of one or more of the partners. But it should not be a name which is misleading, identical, or deceptively or confusingly similar to the name of any other partnership or corporation. Now, from the moment of its creation, the partnership begins to have a personality separate and distinct from the partners which compose it. Meaning that the partnership itself exists apart from the partners. Okay? This in turn results in different relationships, namely among the partners, between the partners and the partnership, between the partnership and third parties that it contracts with, and between the partners and the third parties that the partnership had contracted with. Nevertheless, a partnership is an artificial person with no physical form, so it can act only through its partners who, in general, can bind the partnership if they act within the scope of their authority. Consequently, strangers cannot bind the partnership because they're not part of the contract of partnership, except that in the case of partnership estoppel, where a stranger either directly claims or allows someone else to claim that the stranger is a member of the partnership, and a third person believes that claim and transacts business in good faith with the stranger, believing in good faith that the stranger represents the partnership, can the partnership be held liable? Well, it depends. If all the partners consent to the stranger's claim, then they have effectively accepted the stranger as their agent and authorized the stranger's act because they all consented. So in this case, the partnership will be liable. But if only some, but not all of the partners consent to the stranger's act, then only those will be liable jointly with the stranger. Of course, if none of the partners consent, then the partnership will not be bound because the partnership will not be bound by the act of a stranger. Who you? Okay? In which case, only the stranger will be liable to the third person for both the obligation and his false representation that he was a partner. Now, if there was no partnership in the first place, just people pretending that they are partners in order to fool a third person, and of course, only those who allow themselves to be represented as a partner will be liable. In any case, in a partnership by estoppel, no actual partnership is created. Because remember, to create a partnership, there must be consent, object, and cause. Specifically, the agreement to contribute money, property, or industry to a common fund to divide the profits among themselves. And this is absent in a partnership by estoppel. In the first place, they did not agree. There's no contribution, and then there's no agreement to divide the profits. So therefore, the concept of partnership by estoppel is only a fiction created by law to protect innocent third parties who transact in good faith by preventing the pretenders from evading liability. Now, if a partnership can only act through its partners, what acts can be performed? Well, almost all acts, including acts of ownership, acts of administration, and of conducting partnership business. If it is an act of strict dominion or ownership, like disposing of the goodwill of the business, or renouncing or entering into a compromise on a partnership claim, etc., then the partners cannot act by themselves. They need unanimous consent of all the partners. But if refusal of consent for important alterations on immovable property is manifestly prejudicial, no? The refusal was manifestly prejudicial to the interest of the partnership, the remedy is just to go to court. Now, if it is an act of administration of partnership property, this is usually performed by the managing partner or partners who may be selected either before or after the partnership is created. If only one was designated as managing partner, he may execute all acts of administration which can only be opposed by the other partners if he acted in bad faith. If two or more partners are designated as the managers, well, the best practice in order to avoid confusion and conflict would be either to define their respective duties so each one knows what they can do, or you can require unanimous approval from the other managers for formal transactions, meaning they have to meet and then vote before the transaction can be approved. Okay? And this can only be dispensed with, the unanimous vote can only be dispensed with in case of imminent danger of grave or irreparable injury to the partnership, in which case immediate action is required. Otherwise, if the duties are not defined or unanimous approval is not required, then any one of the managers may execute acts of administration. Now, in case of conflict, such as when a manager opposes the act of another manager, then this may be resolved by a majority vote of the managers. And if their vote results in a tie, then it will be decided by the partners owning the controlling interest. And if there is still a deadlock, meaning a tie, then the vote against the contract will win because it will now be considered as entered into without authority. Now, how do you remove a manager? It depends. If he was appointed in the articles, he can only be removed for just or lawful cause by the partners holding the controlling interest. And if there is no just cause, a unanimous vote of all partners is required to remove him. But if the manager was appointed after the partnership was created, he can be removed at any time for any cause. But as a general rule, if the partnership has an internal procedure, you follow that. And if none, the fairest rule would be majority vote of the controlling interest. Of course, these rules are internal. Okay? And they are not imposed upon and therefore do not affect third persons. In other words, these rules govern only the relationship among the partners. Okay? So any breach of these internal rules will only affect the partner at fault and will not invalidate partnership obligations entered into with third parties in good faith. Now, if no one was designated as manager, the rule is the same as when the Partnerships Act is for the purpose of conducting partnership business, which is that partners are considered agents who can act on behalf of and bind the partnership as long as they act within the scope of authority in conducting partnership business in the usual way. If they do not, then the partnership will not be bound unless the other partners authorize it. Being agents of the partnership, if any partner has knowledge of any partnership matter, this is considered also as knowledge of the partnership as principal, except if the partner is committing or consenting to the commission of fraud against the partnership. So, in partnership obligations, the third person does not have to give notice to each and every partner. Okay? Giving notice to one is considered as notice to all and to the partnership. Also, as agents, the partners owe a duty of loyalty to the partnership and to their fellow partners, consistent with the fiduciary nature of the partnership relation as one being imbued with utmost trust and confidence. As such, a partner must not engage in unfair competition with the partnership unless expressly allowed by other partners. Specifically, a capitalist partner cannot engage in business that is in the same line of business as the partnership, while an industrial partner cannot engage in any separate business at all. Okay? This is because he is expected to devote all his energy toward the partnership. Okay? And in case any partner engages in any act that conflicts with the interests of the partnership, then the partner at fault may be removed or the innocent partners may claim the profits earned by that partner together with damages. Now, in acting for the partnership, a partner's authority may be limited, restricted, or denied in the articles or by special agreement. In this case, if the partner transacts with a third party who does not know of the absence or limitation of authority, then the partnership is bound. Why? Because the third person has the right to assume that the partner is an agent of the partnership who can conduct partnership business. The third person has no duty to inquire into whether the partner has authority or not. Conversely, if the third person knows that the partner does not have or only has limited authority, then the partnership will not be bound, even if partnership business was being conducted. Why? Because both parties were acting in bad faith, knowing that the partner had no power to act or bind the partnership. Of course, if the partner's act is not for conducting the partnership business, such as when he is acting in his own name and for his own account, then such act will not bind the partnership unless the other partners consent to and authorize his act. So, if you want to know if the partnership is bound by the act of a partner, check first what was the act performed. Is it an act of ownership, administration, partnership business, or was it a personal act? Then, check if the partner acted within the scope of his authority. If he did, then the partnership is bound. And if not, you check if the third party knew that the partner was not authorized. If the third party did not know, then the partnership will be bound in order to protect the innocent third person. But if the third person knew that the partner was unauthorized, then the partnership will not be bound because both the partner and the third person were acting in bad faith. So now, if a partner can bind the partnership to partnership obligations, who is liable? Remember that a partnership has a separate personality from the partners. So the partner's own personal obligations are separate from the obligations of the partnership, which should be paid using partnership assets. Once these partnership assets have been exhausted, only then can the individual partners be held liable proportionately with their separate properties to pay partnership obligations. And this is a general partnership where all partners, including industrial partners, are jointly and subsidiarily liable to pay for partnership obligations after the partnership assets have been exhausted. Now, don't be confused with the concept that an industrial partner is not liable for losses. Liability for partnership obligations refer to partnership transactions with third persons. And it is different for liability for losses, which only comes up in the settlement of partnership affairs amongst the partners. Okay, and it has no relation to third persons. So, a partnership creditor can hold the industrial partner liable for a partnership obligation, and the industrial partner has to pay. He will just claim reimbursement from the capitalist partners. So it is only during the distribution of losses that happens during the settlement of partnership affairs amongst themselves that the industrial partner will be exempt. Now, if a person wants to join a partnership but does not want to share in the joint and subsidiary liability in a general partnership, he may instead join as a limited partner in a limited partnership, where one or more general partners have unlimited liability and one or more limited partners contribute money or property but not services as capital, where they share in the profits but they do not participate in the management and they cannot include their name in the partnership name. In exchange, their liability for partnership obligations extend only to the amount of their contributions, meaning that if they have fully paid their contributions, then partnership creditors cannot run after the limited partners' separate property for payment of partnership obligations after the partnership assets have been exhausted. However, if these limited partners participate in management, then they will become liable as a general partner for payment of partnership obligations. Note that unlike a general partnership which is created by mere consent, certain formalities have to be complied with to form a limited partnership, including executing sworn articles, registration with the SEC, and including the word limited in the firm name. If these are not complied with, then only a general partnership is formed. Now, while a general partner's liability is joint and subsidiary, there are cases when a general partner and the partnership are solidarily liable. Namely, first, if a partner wrongfully causes loss or injury to any person, okay, while conducting partnership business. And second, in case of breach of trust where a partner, while acting within the scope of his authority, misapplies money or property which was either received directly from a third person or after it has been received by the partnership. So, we have already discussed several obligations of the partners. And while there is not enough time to discuss everything in detail, here are some other obligations that you should note. First, the partners have a duty to render information of matters affecting the partnership. They also have a duty to convert partnership, not to convert, rather, not to convert partnership money or property to their own use. And if they do, they should reimburse the amount with interest and damages. Next, they also have a duty to account for any profit received which is due to the partnership and to hold it in trust for the partners. Another one is in case a partner receives partnership credit from an insolvent debtor, then he has to share it with the partnership and the other partners. Next, if he causes damage to the partnership through his fault, then of course he has to pay for the damages. And finally, in case a managing partner receives payment from a debtor who owes both the partnership and the manager in his personal capacity, that manager has a duty to apply the payment proportionately to the two debts, except that if he received the money only on behalf of the partnership, then the manager should only apply it to the account of the partnership only. Now, of course, the partners may impose other obligations aside from those obligations, no? And if they have obligations, the partners also have rights. And the most significant would be the partner's property rights, which consist of three things. First, his right to specific partnership property. Second, his interest in the partnership. And third, the right to participate in the management, which we already talked about earlier. So let's just talk about the first two ones. A partner's right to specific partnership property makes him a co-owner of the property. But his right is merely inchoate and can only be determined after dissolution and liquidation. As such, he can only possess the property for partnership purposes. And if he wants to use it for other purposes, he has to first get the consent of the other partners. Moreover, since his right to specific property is not yet determined, he cannot assign it unless all the other partners also assign their respective rights to the property. This is because if he is allowed to assign his right to the property to someone else, then that stranger will become a co-owner in the partnership property and indirectly admitted to the partnership, which violates the principle of delectus personae. Okay? And this is the same reason why a partner's right in specific partnership property is not subject to attachment, execution, or legal support. Now, a partner's interest in the partnership is his share in the profits and surplus. And since this is a partner's personal property, he may choose to associate a stranger in his share and create a contract of sub-partnership where he and the stranger will share in the profits received through the interest in the partnership, or he may even assign his whole interest to a stranger. Okay? Whichever he chooses, it will not result in dissolution of the partnership. Why? Because these acts will not make the stranger into a partner, nor do they grant any right to manage to the stranger. Okay? The only thing that the stranger gets in either case is the right to receive the profits which the assigning partner would have received, because that's what the partner's interest in the partnership is made of. Remember, for a person to be admitted as a partner in a partnership, the consent of all the partners is required, following the principle of delectus personae. So if one partner associates a stranger in his share or assigns his share to a stranger, only his consent is involved. Okay? And the consent of the other partners are not involved. So the stranger cannot become a partner. A partnership relation is not created with a stranger, and therefore the partnership is not dissolved. Okay? Moreover, since a partner's interest in the partnership can be assigned, a partner's creditor may also attach the partner's interest through a charging order in order to satisfy a judgment debt. Nevertheless, in case of conflict between a partnership creditor and a creditor of a single partner over the same partnership property, it is the creditors of the partnership that will be preferred in payment. Now, as with obligations, the partners may choose to grant other rights. Okay, but here are some other rights granted under the law. First, a partner has the right to be reimbursed for amounts that he has advanced on behalf of the partnership and for risks in consequence of management. He also has the right to access, inspect, and copy partnership books, to demand and receive true and full information of all things affecting the partnership as long as it is used only for partnership purposes. Also, the right to demand a formal account under certain instances such as dissolution or when he is wrongfully excluded from the partnership business, and the right to ask for dissolution of the partnership under certain at the right time and under proper circumstances. So far, we've discussed the creation and the incidents in the life of a partnership. But how long does a partnership last? While the law does not set an expiration date for the partnership existence, the partners may agree that the partnership will last only for a limited time or until a particular business is completed. The first is known as a partnership with a fixed term, while the second is a partnership for a particular undertaking. And once the stipulated date arrives or the particular undertaking is completed, then the partnership will be automatically dissolved. If the partners continue the business despite dissolution, a new partnership is created through their implied agreement, which is known as a partnership at will, meaning one which may be dissolved at any time for any reason by any partner as long as it is done in good faith. Now, if it's dissolved in bad faith, the partnership will still be dissolved except that the partner acting in bad faith may be held liable for damages. Of course, in creating the partnership, the partners are not required to choose only between having a fixed term or a particular undertaking. They can choose to create the partnership as a partnership at will from the very beginning, okay, which will continue until it is dissolved. And this brings us to our last topic on the incidents in the end of the life of a partnership, which are dissolution, winding up, and termination. These three concepts are different because dissolution does not automatically result in the termination or the end of the partnership. Dissolution is simply a change in the partnership relation where the partners stop being partners for the conduct of partnership business. In other words, when a partnership is dissolved, it can no longer conduct ordinary business, but it will continue to exist for the purpose of winding up its affairs, which includes liquidation of partnership properties by converting them into cash for distribution to partnership creditors before dividing what remains among the partners, starting with payment of debts or reimbursement, then return of capital, and if anything is left, that will be distributed as profits following their agreement or contribution. It is only after this winding up process is completed that the partnership will be finally terminated or extinguished. Okay? So, three things must be noted. First, after dissolution, the authority of all partners to conduct ordinary partnership business is terminated. They cannot enter into new transactions involving ordinary partnership business. However, the partnership will be liable for new transactions involving ordinary business that were created after dissolution if they were entered into with third parties in good faith who were not given notice of the dissolution. They did not know. Either the partner did not directly give them notice or they had no notice through publication of a notice of dissolution. Otherwise, the only new transactions which may bind the partnership after dissolution are those entered into by the liquidating partner to wind up partnership affairs and to complete unfinished business that started before dissolution. So a liquidating partner is allowed to enter into new transactions on behalf of the partnership to facilitate liquidation, such as to raise money to pay partnership debts, to complete existing contracts, to preserve partnership assets, or to pay for court litigation, among others. Now, in general, dissolution may be caused judicially by filing a case in court or extrajudicially without court intervention. Judicial dissolution can only be caused by a partner or someone who has bought a partnership interest either directly from the partner or pursuant to a charging order to satisfy a judgment debt owing to an individual partner's creditor. So only these two persons can apply for judicial dissolution because a stranger has no interest in the partnership relation. If a partner is the one that is filing, he can choose from the following grounds: that a co-partner is insane or incapacitated, or that a co-partner has breached the partnership agreement, or the partnership is operating at a loss, and others. In the case of the purchaser of a partner's interest, he can apply for judicial dissolution after the end of the specified term or the particular undertaking is completed, or at any time in case of a partnership at will. Extrajudicial dissolution, on the other hand, can only be caused either by an act of a partner or by operation of law. There are several grounds which you can watch in my dissolution episode, or you can study on your own, but some grounds include that the fixed term arrived, the particular undertaking was completed, or even before the arrival of the term or completion of the undertaking, by unanimous decision of all the partners to dissolve the partnership, or by the express will of any partner in good faith in case of a partnership at will. Another ground is, of course, expulsion of a partner in good faith, or if the partnership business becomes unlawful, no, contrary to law, or of course, death, insolvency, or civil interdiction of any partner. In any case, as long as there is a change in the membership, such as when a new partner is admitted, or one or more or of some of the partners assign their interest to the others, or they retire, are expelled, or they die, then the partnership is dissolved. Okay? However, if the partners want, they can continue the business even without having to liquidate the dissolved partnership, as long as they are not the ones who wrongfully caused the dissolution. In this case, the creditors of the dissolved partnership will continue to be the creditors of the new partnership continuing the business, because of course, dissolution does not result in the cancellation of partnership obligations. If you remember your oblicon, dissolution is not one of the modes of extinguishment of obligations. Okay? And in case a person is admitted as a partner into an existing partnership, he will be liable for all the obligations of the partnership even before he joined, except that this liability will be paid only out of partnership property unless there is a stipulation to the contrary. Finally, the partners will now have to change the partnership name to remove the names of the partners who have withdrawn, retired, were expelled, or died, except that the partnership may continue to use the name of a dead partner in the partnership name if they indicate in all their subsequent communications that said partner has died, usually by placing a cross beside the name of the dead partner. Okay, and the partners can also change the name to include the name of a new partner if they want. Okay, so that's it for our overview or review on the law of partnerships. I hope you may have picked up a thing or two, and I hope to see you next time. See you soon. Bye.